Shalom, beloved family. It's your girl Sophia Spiritual Light, and this is like a continuation of our series on the laws of the Most High, essentially. And this is one that I don't think anybody has ever read. And so, you know me, you know how I do. We got to put this into the ley line because I listen to a lot of videos and I see that people want solutions, but people don't understand that the solutions are already there. And yes, part of the solution is filing particular paperwork, becoming a secured party creditor, and all of that. And that is a solution that people absolutely need to do. However, there are other things we can do just by knowing our rights, exercising the rights that we already have, and making them exercise the rights that we have. And so that is what this lesson is in regards to. And this right here that's on the screen is called the Civil Rights Act of 1866. Now, they do have another Civil Rights Act, 1968. They've had another Civil Rights Act, and all those are fine and well. However, this Civil Rights Act is still in play, and that's what you need to keep in mind. It doesn't say the other ones aren't. They say, oh, they said that it replaces that. That's not how that works. That's not how that works. That's not how that works. This is this particular act was ratified by 2/3 of Congress, and therefore it cannot be undone. And so the rights that you are granted in this act, they can't be overridden by any other acts. It doesn't work like that. This was passed by 2/3, not by simple majority like they do stuff now. This was 2/3. And so I want y'all to understand this and think about this as I read it so that you're able to figure out how to um, put it into play and how to think about it. And I'm probably going to do, I'm not going to, I'm going to try not to do too much editorializing. I'm just going to read it and then I'll have a few things to say at the end. We'll go back and look at it. So this says chapter 31. 3 and 1 is 4. Y'all know what to do with that. An act to protect all persons in the United States in their civil rights and furnish the means of their vindication. Be it enacted by the Senate and the House of Representatives of the United States of America and Congress assembled that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States and such citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, except as punishment for a crime whereof the party shall have been duly convicted and have the same right in every state and territory in the United States to make and enforce contracts, to, to sue, be parties, and give evidence to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens, and shall be subject to the like punishment, pains, and penalties, and to none other any law, statute, ordinance, regulation, or custom to the contrary notwithstanding. Section 2. And be it further enacted that any person who, under the color of any law, statute, ordinance, regulation, or custom, shall subject or cause to be subjected any inhabitant of any state or territory to the deprivation of any right secured and protected by this act, or to different punishment, pains, or penalties on account of invalid of such person having at any time been held in a condition of slavery or involuntary servitude, except as punishment for crime whereof the party shall have been duly convicted, or by reason of his color or race, than is prescribed for the punishment of white persons, shall be deemed guilty of a misdemeanor, and on conviction shall be punished by fine not exceeding $1,000 or imprisonment not exceeding 1 year, or both, in the discretion of the court. Section 3. Be it further enacted that the district courts of the United States within their respective districts shall have exclusively of the courts of the several states cognizance of all crimes and offenses committed against the provisions of this act, and also concurrently with the circuit courts of the United States of let me get something because I keep getting lost in all of this wording. Hold on, sorry y'all. Let's see. And also concurrently with the circuit courts of the United States of all causes, civil and criminal, affecting persons who are denied or cannot enforce the courts or judicial tribunals of the state or locality where they may be any of the rights secured to them by the first section of this act. If any suit or prosecution, civil or criminal, has been or shall be commenced in any state court against any such person for any cause whatsoever, or against any officer, civil or military, or other persons for any arrest or imprisonment, trespasses or wrongdoing, wrongs done committed by virtue under the color of authority derived from this act, or the act establishing a bureau for the relief of freedmen and refugees, and all acts amendatory thereof, or refusing to do any act upon the ground that it would be inconsistent with this act, such defendant shall have the right to remove such cause for trial to the proper district or circuit court in the manner prescribed by the act relating to the habeas corpus and regulating judicial proceedings in certain cases, approved March 3, 1863, and all acts amendatory thereof. The jurisdiction in civil and criminal matters hereby conferred on the district and circuit courts of the United States shall be exercised and enforced in conformity with the laws of the United States, so far as such laws are suitable to carry the same into effect, but all cases where such laws are not adapted to the object or are deficient in the provisions necessary to furnish suitable remedies and punish offenses against law, the common law, as modified and changed by the Constitution and statutes of the state wherein the court having jurisdiction of the cause, civil or criminal, is held, so far as the same is not inconsistent with the Constitution and the laws of the United States, shall be extended to and govern said courts in the trial and disposition of such cause, and if of a criminal nature, in the infliction of punishment on the party found guilty. Section 4. Let me scroll up. And be it further enacted that the district attorneys, marshals, and deputy marshals of the United States, the commissioners appointed by the circuit and territorial courts of the United States, with powers of arresting, imprisoning, or bailing offenders against the laws of the United States, the officers and agents of the Freedmen's Bureau, and every other officer who may be specially empowered by the President of the United States, shall be and they are hereby specially authorized and required at the expense of the United States to institute proceedings against all and every person who shall violate the provisions of this act and cause him or them to be arrested and imprisoned or bailed, as the case may be, for trial before such court of the United States or territorial court by this act has cognizance of the offense, and with the view of affording reasonable protection to all persons in their constitutional rights of equality before the law, without distinction of race or color or previous condition of slavery or involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, and to prompt discharge of all duties of this act. It shall be the duty of the circuit courts of the United States and the superior courts of the territories of the United States from time to time to increase the number of commissioners as to afford speedy and convenient means for the arrest and examination of all persons charged with a violation of this act, and such commissioners are hereby authorized and required to exercise and discharge all the powers and duties conferred to them by the act, and the same duties with regard to offenses created by this act, as they are authorized by law to exercise with regard to other offenses against the laws of the United States. And be it further enacted that it shall be the duty of all marshals and deputy marshals to obey and execute all warrants of precepts issued under the provisions of this act, when to them directed, And should any marshal or deputy refuse to receive such warrant or process when tendered, or to use all proper means to diligently execute the same, he shall, on conviction thereof, be fined the sum of $1,000 to use of the person whom the accused is alleged to have committed the offense, and the better enable the said commissioners to execute their duties faithfully and efficiently in conformity with the Constitution of the United States and the requirements of this act. They are hereby authorized and empowered within their counties, respectively, to appoint in writing under their hands any one or more suitable persons from time to time to execute all such warrants, and other process may be issued by them in the lawful performance of their respective duties. And the person so appointed to execute any warrant or process aforesaid shall have authority to summon and call to their aid the bystanders or posse comitatus of the proper county, or such portion of the land of or naval forces of the United States, or of the militia, as may be necessary to performance of the duty which they are charged, and to ensure a faithful observance of the clause of the Constitution which prohibits slavery, in conformity with the provisions of this very act. And said warrant shall run and be executed by said officers anywhere in the state or territory within which they are issued. Section 6. And be it further enacted that any person who shall knowingly and willfully obstruct, hinder, or prevent any officer or other person charged with the execution of any warrant or process issued under the provisions of this act, or any person or persons lawfully assisting him or them from arresting any person for whose apprehension such warrant or process may have been issued, or shall rescue or attempt to rescue such person from the custody of the officer, other person or persons, or those lawfully assisting as aforesaid, when so arrested pursuant to the authority herein given and declared, or shall aid, abet, or assist any person so arrested as aforesaid, directly or indirectly, to escape from the custody of the officer or other person legally authorized as aforesaid, or shall harbor or conceal any person for whose arrest a warrant or process shall have been issued as aforesaid, as to prevent his discovery and arrest after notice or knowledge of the fact that a warrant has been issued for the apprehension of such person, shall for either of said offenses be subject to a fine not exceeding $1,000 and imprisonment not exceeding 6 months by indictment and conviction before the District Court of the United States district in which said offense may have been committed, or before the proper court of criminal jurisdiction if committed within any one of the organized territories of the United States. And be it for Section 7, and be it further enacted that the district attorneys, the marshals, their deputies, and the clerks of said district and territorial courts shall be paid for their services, the like fees, and may be allowed to them similar services in other cases. And in all cases where proceedings are before the commissioner, he shall be entitled to a fee of $10 in full for his service in each case, inclusive of all services incident to such arrest and examination. The person or persons authorized to execute the process to be issued by such commissions for the arrest of the offenders against the provisions of this act shall be entitled to a fee of $5 for each person he or they may arrest and take before any such commissioner as aforesaid, with such other fees may be deemed reasonable by a commissioner for such other additional services as may be necessarily performed by him or them, such as attending at the examination, keeping the prisoner in custody, and providing him with food and lodging during his detention until the final determination of such commissioner, and in general for performing other duties as may be required in the premises. Such fees to be made up in conformity with the fees usually charged by the officers of the courts of justice when the proper district on or county as near may be practicable, and paid out of the Treasury of the United States on the certificate of the judge of the district within the arrest is made, and to be recoverable from the defendant as a part of the judgment in case of conviction. All right, we're almost done. Section 8. And be it further enacted that whenever the President of the United States shall have reason to believe that offenses have been or likely to be committed against the provisions of this act within any judicial district, it shall be lawful for him in his discretion to direct the judge, marshal, and district attorney of such district to attend at such place within the district and for such time as he may designate for the purpose of more speedy arrest and trial of persons charged with a violation of this act. And it shall be the duty of every judge or other officer when any such requisition shall be received for him to attend at the place and for the time therein designated. 9. Section 9. And be it further enacted that it shall be lawful for the President of the United States or any such person as he may empower for that purpose to employ such part of the land or naval forces of the United States or of the militia and shall be necessary to prevent the violation and enforce the due execution of this act. Section 10. And be it further enacted that upon all questions of the law arising in any case under the provisions of this act, a final appeal may be taken to the Supreme Court of the United States. And this is Schuler Colfax, Speaker of the House of Representatives, Lafayette S. Foster, President of the Senate pro tempore in the Senate of the United States, April 6, 1866, which you have nine, you have April, which is 4, and 6, which is 10, and then 1866 that comes down to 999, 666, or 99966, which you know what to do. The President of the United States. So basically, you have 10 and 9. Um, 10 and 9, which is 19. Oh wait, well, that's not 10 and 9. 6 and 6 is 12. I mean, yeah, 6 is 12. 12 and 6 is 18. 6 times 3 is 18. 6, 12, 18, 19, 20, 21. So 21 and 6 is 27. And 4 is 31, which is 4. All right. The President of the United States, having returned this to the Senate, in which it originated, the bill entitled An Act to Protect All Persons in the United States and Their Civil Rights and to Furnish the Means of Their Vindication, with his objections thereto, the Senate proceeded, in pursuance with the Constitution, to reconsider the same and resolve the said bill do pass, two-thirds of the Senate agreeing to pass at the same. Attest, this is J.W. Forney, Secretary of the Senate, in the House of Representatives, April 9th. We got April 6th and April 9th, 1866. The House of Representatives having been proceeded in pursuance of the Constitution to reconsider the bill entitled An Act to Protect All Persons in the United States in their civil rights and furnish all means of their vindication, returned to the Senate by the President of the United States with his objection and sent to the Senate to and sent by the Senate to the House of Representatives with the same message of the President returning the bill. Resolved, the bill do pass, two-thirds of the House of Representatives agreeing to pass the same. Attest is Edward McPherson, Clerk, and Clinton Lloyd, Chief Clerk. Okay, so here you have the Civil Rights Act of 1866. And I'm just going to have some commentary as soon as I stretch. Sorry. So the first thing is, what is this right protecting? I just want you to understand that. It says it. In the first thing, you have the right to make and enforce contracts, to sue, to be parties and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings. Wait a second. What does that mean? Meaning every law that any other person, especially a 14th Amendment person, has legal access to, you as a citizen have access to. Now, what does that mean? That's going to be in a separate video as to hopefully not draw too much attention to my channel. But that all laws and proceedings, not just some, all laws that everyone else, including um people who get off for stuff doing stuff that you can't get off for, you're supposed to have access to that same law that they have access to. All right. So section 2, it says that so the first part about section 1 is that you are a citizen. So all of this argument about who's a citizen and who's not a citizen, Da, 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 da. If you're here, all persons born in the United States and not subject to any foreign power are hereby declared to be citizens. So if you're born in the United States, according to this law, you're declared to be a citizen. So there are a lot of people who are subject to foreign power, like the vice president, who are not citizens because they were born here, yes, but they're not subject to the laws here. So they can't use the law when they feel like it and then not use it when they don't feel like it. And so this is just more fuel to that fire, because if you're subject to any foreign power, you can't be a citizen. Even if you're born here, if you're subject to a foreign citizen, to a foreign power, you can't be a citizen. Therefore, whoever certified that person, as a person who is legally allowed to be a serve in the role, that they are serving in currently, they are actually committed fraud. Okay, because that person, when they were born, was subject to a foreign power being Britain, on both sides, because that person's mother was born in India, which is British control, and Jamaica, which was British control. So that person is subject to a foreign power, and we have that documentation. That's neither here nor there. Section 2. What section 2 is saying is that if anybody breaks this law, they have to be, they have to pay a fine and they have to be imprisoned, or both, or one or the other, or both. Okay, that's what section 2 is saying. If they try to, if they deprive you of any right secured by section 1, which is access to all laws. So if anybody denies you the right to access all laws under section 1, that person actually is going to have to pay a fine and be in prison. So a lot of people know people who are incarcerated. Y'all are not using this. All right. And it says in the last section, you take your appeal to the Supreme Court. You don't take your appeal to the district court, you take your appeal to the Supreme Court. So a lot of people have already filed appeals, whatnot. You want to take that appeal to the Supreme Court, okay? All right. Then it says the district courts have to hear these cases. That's section 3. And then it says the district attorneys have to put these people in jail. They're required to by this act. Section 5 says that anybody, once a warrant is issued, they have to serve the warrant. They can't, like they did with that person who murdered Emmett Till, say they can't find the person, drop that issue. They're not allowed to do that. So, if you're looking for a remedy for that, section 5 is right here. They violated the law. They're not allowed to do that. And those people can go to jail for this. Um, and then section 6, if you willingly obstruct the enforcement of this law, like many people are doing, including your lawyers that you have on your cases, they're obstructing the enforcement of this law, they actually also have to be punished. And the district attorneys, you know how much they're supposed to be paid? They're only supposed to get $10. So their salaries need to be reduced to $10. Okay, and $5 if you bring somebody in. That's what they're supposed to be paid. We should make them be paid $10. All right. And the president can do stuff and blah, blah, blah. We don't care about that. But Section 10, yeah, a final appeal can be taken to the Supreme Court. And the Supreme Court has to hear it under this law. They have to. They have to. They have to. And so I'm going to put the link to where I got this copy. This is not the best copy. It is very difficult to read. You're probably going to have to figure out how to print it. I have another copy. If anybody wants it, they can email me and I'll email them my copy, which is easier to read. This copy is very difficult to read with this typeface, but you get the point. So people are looking for remedies for a lot of situation. We already have the remedy. The remedy is you are entitled equal access to every law. What does every law mean? That means every accounting law that they use, every financial law that they use that they tell you you can't use, you're entitled access to that law. And if they have broken that, you are entitled to go to the court and get remedy. And your remedy is they have to pay, and that fine actually is supposed to go to you. So and they're supposed to go to jail. And if the district court won't hear your concern, you appeal to the Supreme Court. So a lot of people who have particular issues, here is a quite a bit of your remedy right here if you use this act as stated. And again, if you have people who are they were duly unduly incarcerated, you use this law because they violate a lot of times they violated your rights in order to arrest you. They can't do that according to this. And if they do, they have to be held accountable. So people are looking for ways to hold people accountable. This is your friend right here. And so I just wanted to encode it into the ley line. Y'all know how I am. And to the spirits who are here with us, you're invited to go in peace. To my beloved viewers, you're invited to be in peace. And always remember, the Most High is your peace. Shalom.